Did you know that there are rules established in law which provide that in case of gang rape and murder of a Dalit victim, the family of the victim is eligible for a pension of Rs 1,000 per month, of employment to one member of the family of the deceased, or provision of agricultural land, a house if necessary, by outright purchase. 5 years after the gang rape of a young Dalit woman in Hathras, Western UP, a member of the family is yet to be provided employment despite the Allahabad High Court ordering this last year in July 2022. In fact, in defiance of the High Court ordering such employment be given and the family be relocated, the UP government had challenged this in the Supreme Court. At the time, a 3-judge bench of Chief Justice of India D.Y. Chandrachud, P.S. Narasimha and Justice Pardiwala had dismissed this and expressed surprise at the attitude of the UP government challenging a simple act of reparation. People, men and women all over the country protested with outrage across India at this ghastly gang rape and murder that took place on September 14, 2020. Several petitions had been filed in the Supreme Court of India. In our intervention, Citizens for Justice and Peace had prayed for protection by the CRPF, a prayer granted in the final orders of the Supreme Court. Within a month, the Allahabad High Court had taken suo motu action. In the first hearings, harsh words were used by the Allahabad High Court, which said the incident has evoked disgust amongst the public at large, as is borne out from newspapers, TV channel programs, and has been condemned by all. In its 11-page order, first of many, in October 2020, the court had reminded the UP government and its officials of their accountability to the Indian Constitution and their responsibility to the people. In July 2022, the High Court ordered that the UP government provide employment to one of the family members, as well as relocate them to some other place outside Hathras, given their socio-economic situation and the educational needs of the children. This was because none of the male members of the victim's family were getting any employment due to social ostracism because of their caste status and their determined battle for justice for their lost one. Despite this, the attitude of the UP government remains unrepentant 5 years down, not even providing the family with employment. August 28, 2023, the High Court was informed by the amicus curiae that the Uttar Pradesh government has not yet complied with its own order, the Allahabad High Court order, to provide employment to one of the members. Amicus Jaideep Narayan Mathur also informed the court that the family has not been relocated. Who is an amicus curiae? Appointed by the court, she or he is the impartial advisor to judicial proceedings in a case of social consequence. Cases of sexual abuse, assault and rape committed against women, especially women belonging to the scheduled castes and scheduled tribes, mark an everyday shameful reality. What makes the Hathras gang rape case one of the worst such cases in the complicit and callous role by the UP government and administration in shielding the perpetrators? Before she had died, she had recorded a dying declaration with the police naming Sandeep and another person as the perpetrators of the crime. She even made a supplementary statement before the magistrate and named Sandeep, Lavkush, Ravi and Ramu as assailant and accused them of sexual assault. A dying declaration is a statement made by a declarant as to the cause of their death. Under Section 158 of the Indian Evidence Act 1872, a dying declaration of the person in cases where the declarant dies is admissible evidence in the case. Dying declaration cannot be used as the sole basis for conviction. It forms a crucial bit of corroboratory evidence once the facts have been established. Shockingly, the police had only taken cognizance of her allegation of rape a full 8 days after the incident. It was only on September 22, 2020, 8 days after the alleged gang rape had taken place, that a swab test to ascertain sexual assault was conducted on the survivor. Since it is well established that forensic evidence can only be found up to 96 hours after the incident of rape, chances of finding evidence of sexual assault, such as sperm, were next to impossible. Another serious and grave violation by the UP police was when they hastily cremated the victim in the middle of the night on September 29, 2020, preventing any involvement of the family. They had not handed over the body of the victim to the family despite their pleas. The story does not end here. Special court acquits 3 accused, holds 1 guilty of culpable homicide not amounting to murder. The sole person convicted was not even held guilty of murder. Special Judge Trilokpal Singh stated that Section 302 murder charge under the IPC cannot be invoked in the Hathras case, as the intent of the prime accused Sandeep to kill the victim could not be established. Cases of sexual abuse, assault and rape committed against women, especially women belonging to the scheduled castes and scheduled tribes, mark an everyday shameful reality. What makes the Hathras gang rape case one of the worst such cases in the complicit and callous role by the UP government and administration in shielding the perpetrators? 5 years down, the family carries on its lone struggle for justice with little support. Should justice not be done? Reparation, including employment and a dignified life, not be made available to the family? Do they not deserve to be relocated to a place where they do not face a threat to their lives? Was the grave crime that took place in Hathras against one family, or was it against society at large? A humane society that wants to empower and ensure safety for all women.